Hello, everyone, and welcome back to Straight Down the Middle. You know, since I released episode 1, I have gotten a ton of follow-up questions about the Trump verdict, the Trump hush money verdict. So what I thought I'd do is a little Q&A session answering some of the most frequently asked questions. Okay, first question. Can Trump pardon himself for this crime if he's elected? Answer to that question is simple. No, he cannot. The president's power to pardon is limited to federal crimes. It does not apply to state crimes. So even if the president does have the authority to pardon himself, and some people don't think he does, but even if he does have that authority, President Trump, if elected, could not pardon himself for this offense, which is a state law offense. Okay, second question. Conflict of interest. A lot of people have said to me, Professor, I've heard that the judge in the case, Judge Mershon, had a conflict of interest which should have disqualified him. Can you say a little bit more about that? The folks who are making this point about Judge Mershon, they're really pointing at two things. First, Judge Mershon made a donation, a campaign donation back in 2020, small donation, but nonetheless a donation to the Biden-Harris campaign. Is that unusual? Yes, it is. In fact, it's prohibited under New York law. Judges are not allowed to make campaign donations. Second thing they point to is the judge's daughter. Judge Mershon has a daughter, grown-up daughter, who runs a political agency. It offers services to political campaigns like fundraising, and their clients tend to be on the Democratic side. In fact, on the website, the agency lists itself as a progressive agency, and one of their clients, according to the website, is the Biden-Harris campaign. Now, according to the critics, Judge Mershon's daughter stands to profit. This is a multi-million-dollar agency, stands to profit to the tune of millions of dollars if Trump is convicted in this case. And if true, that's a problem. Now, I don't know if it is true, but if it is true, that's a serious issue. You got a member of the judge's family profiting from a conviction in this case. Obviously, that would be troubling. But here's what I got to tell you. Neither of these things, the donation or the judge's daughter's agency, neither of them may be enough to count as a conflict of interest in the strict sense in which the law defines it. That is, it may not have been the case that Judge Mershon was legally required to recuse himself. But, you know, I also got to tell you this. In a case like this, of this magnitude, the appearance of impartiality was so important and is so important. And the appearance that the judge has no bias was so important and is so important. So I got to tell you, even if the judge wasn't legally required to recuse himself, maybe in the interest of avoiding the appearance of impropriety, the appearance of partiality, maybe the judge should have recused himself many months ago. Okay, let's turn to the next question. Statute of limitations. Many people have asked me this. They say, I heard, Professor, that there's a statute of limitations issue in this case. Can you say something more about that? You got to remember, Trump was charged with a two-step crime, falsifying business records in order to conceal another crime. And it's that other crime, that's what's causing all the problems in this case. Falsifying business records, that's a misdemeanor under New York law. But falsifying business records in order to conceal a second crime, that's a felony. Now, a lot of people are saying, well, how come District Attorney Bragg, that's the Manhattan District Attorney who brought the case, how come he didn't just charge the misdemeanor and avoid all these problems with the second crime? Why didn't he just charge the misdemeanor and could have found President Trump guilty of the misdemeanor? It would have been much simpler, right? No, it would not have, because he could not do it. Why couldn't he just charge him with the misdemeanor? Very simple. Statute of limitations. The statute of limitations under New York law for the misdemeanor offense of falsifying business records, just a couple of years. And that statute had already run by the time Bragg brought the prosecution against Trump. So he could not charge him with the misdemeanor. But the statute of limitations for the felony offense, that was more years, and that had not run by the time he brought the prosecution against President Trump. So Bragg had to bring the prosecution as a felony prosecution. You know, I'm sure he wanted to anyway, because the felony is a much more serious offense, but he had to. So that's part of why we are where we are. Okay, next question. A lot of people have said this. Professor, we hear you saying that the prosecution never identified to President Trump what the second crime was. Falsifying business records in order to conceal a second crime. And you've said they never identified and specified what the second crime was. But wait, isn't it true that in his jury instructions, Judge Mershon did identify the second crime? Didn't he say to the jury, the second crime is a violation of a New York election law statute? He was very specific about it. And so he did identify the second crime. Well, you know what? That's exactly right. But here's the problem. Under our Constitution, an accused has the right to be informed of the specific offense with which he's charged before the trial, in advance, so that he can prepare his defense. That's the whole point of the constitutional right. It's not okay if the state and the judge identify the specific charge at the end of the trial in the jury instructions. That doesn't cure a Sixth Amendment violation. Okay, next question. This comes from Esther Fitzgerald in Texas. And Esther asks an excellent question. Well, if President Trump's Sixth Amendment rights were violated, when can he assert them? Does somebody have to wait until they're fully convicted and sentenced before they can raise their Sixth Amendment rights and assert that their Sixth Amendment rights were violated? Answer, no, they do not have to wait. If the Sixth Amendment rights of an accused are violated at any time during criminal proceedings, the accused can raise it right then and there at many different stages in the criminal proceedings before and after conviction. So, short answer, no, President Trump did not have to wait, does not have to wait. And in fact, his lawyers did make an argument of this kind. They said to Judge Mershon, we have a right to know what the second crime is. We are asking for a bill of particulars from the state to tell us what the second crime is. But Judge Mershon rejected that request and said, no, as I read the law, said Judge Mershon, President Trump has no right to have that second crime specified. Judge Mershon specifically held that in this case back in February. Now here's the problem. Judge Mershon looks like was making that decision under New York law. He was saying under New York law, as I read the cases, I'm not required and the state is not required to specify the second crime. But here's the thing. Constitutional law trumps, if you'll excuse the term, New York law. New York law is inferior to constitutional law. If constitutional law requires that the accused be informed of the specific offense, that's the end of the matter. And constitutional law does require that. So if Trump was not informed in advance of the trial of the specific offense with which he was charged, that was a violation of his Sixth Amendment rights. That makes the whole prosecution unconstitutional. You guys have been asking me great questions. I hope you'll keep doing it. You can post those questions to me on YouTube or X, and I will try to answer as many of them as I can on YouTube or X, or I might feature them in a future episode. So keep throwing them at me, and I'll try to answer them. I'll be doing more episodes on the thorny unanimity issue. I'll do one on the question of whether this was all a political prosecution and what we should make of that. And I'll do more episodes as the month of June goes by when the Supreme Court starts issuing some of its major decisions. If that's of interest, and I hope it is, I hope you'll tune in. Thanks and goodbye.
'Cause the flag still stands for freedom, and they can't take that away.